Hello, and welcome to this episode of the Hare Court Chambers Travel and Aviation Law podcast series. My name is Richard Campbell, and today I'm joined by Christopher Loxton. Both Chris and I are barristers at Hare Court and members of the Travel and Aviation Law teams. In this podcast, Chris will outline the principal legal requirements thrown up by the global epidemic in the context of air travel and highlight liability issues for airlines and other industry operators. Now, given the shifting nature of the pandemic, this podcast provides a limited snapshot as of the 17th of August 2020 of a situation that is liable to change as much going forward as it has in the last couple of months. Now, Chris, before we get into the legal aspects of this very pressing topic, what has been the impact of the COVID-19 pandemic in real terms on the air travel industry?
Well, firstly, hi, Richard. Second, to answer your question, well, there's no doubt the impact of the COVID-19 pandemic on global air travel has been unprecedented. ICAO, the International Civil Aviation Organization, which is a UN agency that helps manage international aviation, estimates that for the first quarter of 2020, there was a reduction of 612 million passengers compared with 2019, with international air traffic expected to decrease by 50% for 2020 as a whole, as compared to 2019 figures. So that's pretty stark. And then the global trade body IATA, International Air Transport Association, estimates that airlines will lose nearly $500 billion in revenue in 2020. And that again represents roughly a 50% reduction in revenues when compared with 2019. And then specifically in the UK, which is the world's third largest aviation market, the National Air Traffic Service estimates that air traffic in April was down by almost 90% compared with figures for the same period last year for Western, and similar reductions for other Western European countries.
Right. Well, it sounds a pretty bleak picture at the moment. But are there signs of there being light at the end of the tunnel?
Well, a little bit, yes. I think based on the air traffic patterns from Eurocontrol, from a low of less than 2,500 daily flights in Europe in mid-April, there are now around 16,500 daily flights in August within Europe, though the latter figure still represents overall a 50% reduction on flights in the same period of 2019. So there's definitely been an uptake, obviously, since the lockdown measures came into force across Europe, but we're still more than half down from what we would expect traffic figures to be like this time last year. And in an effort to protect public health, whilst reviving domestic and international air travel, we've seen a myriad of legislation and guidance issued by both the UK government and authorities and international bodies in recent months, which airlines and airport operators have been scrambling to comply with.
Well, yes, let's turn to that legal landscape and the new legislation here in the UK. Now, it wasn't too long ago that we were deep in lockdown, but those restrictions have started to ease now, haven't they?
Yes, thankfully. Well, the now perhaps infamous restriction contained in the Health Protection Coronavirus Restrictions England Regulations 2020. They've all got very snappy titles, as I think we'll hear throughout this podcast. But those regulations initially permitted people resident in England to leave their place of residence only with a reasonable excuse. Now that was removed, as we perhaps not remember the exact date, but that was removed back on the 4th of July. So there are no restrictions on travelling abroad per se now. However, there are specific requirements that exist for entry into the UK, particularly in travelling from certain countries, most recently, of course, France, which was last weekend. So in terms of those regulations, those restrictions, well, on the 3rd of June, Majesty's government laid before the UK Parliament 2 statutory instruments applicable in England. And I'll briefly just talk about devolved UK administrations, but the English ones were, again, come long titles which will shorten, but the Health Protection Coronavirus International Travel England Regulations, which I think we're going to refer to as the International Travel Regs. And then secondly, the Health Protection Coronavirus Public Health Information for Passengers Travelling to England Regulations, which we'll call the Health Information Regs. And as I just mentioned, the devolved UK administrations each introduced similar statutory instruments, with all instruments having come into force in June. There are, however, a few significant differences between the English legislation I've just named and its counterparts in Scotland, Wales, Northern Ireland, and therefore listeners in devolved areas other than England are advised to consult the relevant statutory instruments as to what we'll be discussing today only relates to English legislation.
Great. Well, let's perhaps take those in turn then. So starting with, as you say, the snappily titled Health Protection Corona International Travel England Regulations 2020, the International Travel Regs, that's what we'll call them from now on. What are their main requirements?
Okay, well, those regulations contain two principal requirements, which I'm sure listeners will be have heard quite a lot in the press about. The first is for travellers into England to provide information, including contact details and details of their intended onward travel. There are quite a few details there to be provided, but those are the principal ones, and they are found in Regulation 3 of the International Travel Regs. And then the second principal requirement is for travellers to self-isolate, otherwise known as self-quarantine, I think, by most of the press, for a period of 14 days following their arrival in England, if they've arrived from certain countries or territories. So to break that down a little bit more, all persons arriving in England from what's known as from outside what's known as the common travel area, and the common travel area being defined as the UK and the Republic of Ireland. If you have travelled from outside there, then you're required to provide information on what's called a passenger locator form, a PLF, on arrival. Now, the information required on the form includes your name, home address, date of birth, contact details, passport number, and quite substantial details about your onward travel. And those are all set out in Schedule 2 of the regulation. And for adults who are travelling with children, their responsibility is also complete forms for each of their parties. That would include any children they're travelling with. Now, in terms of the sort of format of that, the definition of a passenger locator form in Regulation 2 makes clear that the form is published in digital or electronic form only. It started off being in hard copy back in June, but it's now gone unsurprisingly digital. Although I understand anecdotally that hard copy forms are still available at UK airports when you arrive if you've not yet completed it online. And online you complete it on a .gov.uk website prior to your arrival, not more than 48 hours in advance. If you type in simple Google search, it will take you to the gov.uk website, and you start what's almost like a questionnaire, which takes you to the form and where to complete it.
Okay, and so might there be situations where an individual doesn't have to fill in a PLF?
There is, yeah. The regulation sets out about 12 categories of persons in paragraph 1 of Schedule 2 of the regulations, which broadly cover people who are exempt, and allow people who are working for foreign governments or international organisations, crown servants or government contractors carrying out, I quote, essential government work related to the UK border, or those sorts of people, in other words, crown servants, government contractors, or military personnel from designated foreign countries carrying out necessary work to the delivery of essential defence activities. All that work has to actually be carried out within 14 days of your arrival in England. So I think the short answer is persons who think they qualify as being exempt fall into a category set out in Schedule 2, are advised to obviously check with their employer and the UK Border Force before travelling.
Now, I suppose the aspect that the media and indeed most holiday makers are concerned with are the provisions pertaining to self-isolation. Let's touch on those now. When would an individual have to self-isolate?
Well, as I mentioned, yes, the second requirement in the regs to self-isolate for 14 days from their arrival. But that's, again, broadly two scenarios, one of which is if they have arrived in England from a non-exempt country or territory, which is a country or territory not listed in Schedule A1 of the regulations, or secondly, if they've arrived in England from within the common travel area, and that's again, by way of reminder, the UK or the Republic of Ireland. If they say they've arrived from one of those countries, but have been to a non-exempt country or territory within 14 days of their arrival in England, then they also have to self-isolate. So in other words, if you've been to a non-exempt country or territory within 14 days of your arrival from England, then you have to self-isolate for that period of time.
But as those venturing to Spain found out the hard way, the exempt and non-exempt country list can change at a moment's notice, can't it?
Yes, absolutely. And of course, the announcement about France came late last week with very little notice for people already abroad in that country. I mean, I think a bit more notice than those people who were out in Spain. And now, as I mentioned, there's the list of non-exempt countries and territories. And in other words, they are countries or territories not listed in Schedule A1 of the regs. Now, whilst that is legally correct, the regulations themselves are not updated nearly as quickly as the list on the Commonwealth Office's website. So people are advised to check that website for the latest on which countries are exempt or not. So for example, this morning, I looked at the international travel regs, and France was still listed as a country which was permissible to travel from and not self-isolate, but clearly when you go to the Foreign and Commonwealth Office's website, it's very much a country that's not exempt. In other words, you do have to self-isolate upon arrival from France. So yeah, check the website for the most updated version.
Yes, remain vigilant, or just follow the newspapers to be clear as to what's changing on a day-to-day basis. Right, okay, well, let's turn to the other main statutory instrument you mentioned, namely the Health Protection Coronavirus Public Health Information for Passengers Travelling to England Regulations 2020, or as we'll say, the Health Information Regulations. I suspect it does what it says on the tin, but what do these regulations say?
Yes, they do. They are quite prescriptive, but I'm going to talk about also there's a government guidance which is necessary to follow as well. These regulations are very much aimed at transport operators, so they don't apply to passengers, but the key to this is obviously providing information to passengers so they know themselves what their rights and responsibilities are. So Regulation 3 of the Health Information Regs requires air, sea and rail operators to ensure that passengers who arrive in England from outside the common travel area on such services have been provided with certain public health information in the required manner, and that manner is set out in Regulation 4. And this information has to be provided on 3 separate occasions. One is where prior to departure a booking was made for a passenger to travel on either air, sea or rail before the booking was made. 2, where prior to departure the passenger was checked in to travel on the relevant service at the time of check-in. And 3 is while the passenger was on board the vessel, aircraft or train. So in essence, before departure, at the time of booking, prior to departure at check-in, and thirdly, when you're actually boarding or on board the particular vessel, aircraft or train. Now, Regulation 3 is actually punishable as a criminal offence by a summary conviction by a fine. And Regulation 4, which I mentioned, which sets out the required manner of the information. For the purpose of that, the Secretary of State for Transport has placed on the website, gov.uk website, a statement. And so that forms, in essence, part of the required legislative requirement as to what information you're supposed to give passengers. And in essence, that's information obviously about the coronavirus, the disease and related duties and public health guidance. Now that statement that was published by the Secretary of State, published on the 5th of June, remains up to date, and operators must read that statement in full as it sets out what information they must publish to passengers at the booking stage, at check-in and whilst on board the vessel and aircraft. Regulation 6 of the health regulations requires operators to keep records and to provide authorised persons with copies of those records and, I quote, other information about how they're complying with the requirement to provide information to passengers. The persons who are authorised to receive records are the Secretary of State for Transport when it comes to marine operators, the CAA for air operators, and the Office for Rail and Road for rail operators. And again, breach of the Regulation 6, so to provide and keep records, breach of that is also punishable as a criminal offence on summary conviction by a fine. Both the international travel regs, which we've covered, and the health information regs contain statutory review mechanisms which call for review by the Secretary of State for every 28 days. That's of course taken place, I think, twice now, and they have been slight amendments, but obviously they've been kept in large part.
Now, further to obviously these very important instruments, we saw aviation-specific guidance from the Department of Transport, didn't we?
We did, yes. The Department of Transport, DFT, released aviation-specific guidance on the 11th of June. That's entitled Coronavirus COVID-19 Safe Aviation Guidance for Operators. I think the last time it was updated was 24th of July. And in summary, that guidance, it's quite lengthy, but in summary, it sets out 6 main areas. One is the need for operators to produce specific workplace risk assessments dealing with the virus. 2 is guidance setting out factors to determine who should be in the workplace and who can work from home and who should be self-isolating. Of course, that's the same for all employers should be doing that. 3 is determining the level of social distancing, amount of PPE and personal hygiene measures for workers and passengers. 4 is workplace planning to ensure social distancing and other infection control measures are adhered to amongst workers. 5 is similar measures for protecting passengers, so maintaining social distancing and other infection control messages for them. Of course, the guidance unsurprisingly emphasised the importance of good communication with passengers to ensure that, things like very good signage at airports and on board aircrafts. And then lastly, biosecurity measures at all stages of the passenger's journey. So, as I just touched on, perhaps at the airport, through to arrival and departure at the airport, and then being on board the aircraft, and finally departing the airport. And then there's also guidance, more general guidance, called National Transport Operator Guidance, and that obviously deals with transport operators, not just for aviation, but in rail and sea as well. And they additionally cover 4 main areas, one of which is emergency incidents. So how does one respond to emergency incidents, trying to ensure a best practice for biosecurity, COVID protection measures. 2nd is cleaning. 3rd is ventilation, and 4th is communication and training. So that more general guidance, together with, for aviation operators, the aviation-specific guidance is a must-read and must-adhere-to guidance.
And before we turn to liability considerations, obviously those are the main aspects of the legislative landscape, but are there any other guidelines the air industry should be aware of at this time?
Yes, there is. The other vital guidelines for airlines and airports and other air transport operators to observe is the European Aviation Safety Agency, ESA's, guidance entitled COVID-19 Aviation Health Safety Protocol. Of course, ESA is the European regulator, so particularly, including for UK carriers, whilst we are in the transition period, it is mandatory to follow the ESA's guidance. And then also there's ICAO's guidance from their Council Aviation Recovery Task Force, which they set up in response to COVID-19. And that guidance is entitled Takeoff Guidance for Air Travel Through COVID-19 Public Health Crisis. Those overlap to a large degree, but are, again, important guidance for carriers and other airport transport operators to adhere to. The CAA hasn't released its own comprehensive guidance, again, most likely due to the fact that they are not, as yet, the UK regulator for UK airports and carriers. ESA's guidance will trump any guidance issued by the CAA. But of course, given that they haven't done so, operators are advised to follow the aforementioned UK guidance and ESA's guidance as bare minimums to ensure regulatory compliance.
Now, obviously, that's a lot to take in. It seems to be changing on almost a daily basis, and indeed, certainly has its complications in relation to implementation. I mean, how do you think the air industry has, or indeed will, respond to these requirements?
Well, the signs are that airlines and other air operators have, on the whole, been quick to adhere to the legislation and guidance. And certainly most European airlines and airports have introduced, for example, mandatory online check-ins, automated check-in and bag drop procedures at airports, and the provision of PPE, including things like face masks at airports and on board aircraft for those who haven't brought their own. And there's been a understandable simplification of in-flight refreshments. So those are things that, on the whole, most have done. I've certainly heard of certain airports and airlines that have been far worse than others. So I think the key to this is consistency, obviously, within the industry. That's going to be crucial in order to see passenger numbers increase.
Yes, absolutely, and it sounds as though a lot of airlines and airports are taking it seriously. But what do you think are the liability implications for those airlines and airport operators who have perhaps been below par in complying with the legislation and guidance?
Well, in terms of potential claims, I think causation is going to be a tricky proposition for anyone seeking to blame an air operator for the fact that they've contracted COVID-19. That said, with the increase in sophistication of COVID contact tracing apps, this may change, and therefore operators shouldn't disregard this as a risk. I think certainly in the short to medium term, though, the risk to corporate reputation is very much evident. So poor biosecurity measures, such as lack of social distancing or masks or lack of hygiene product provision at airports or on board aircraft, is likely to attract significant social media attention by disgruntled customers. And that's obviously something which operators are going to be keen to try and avoid.
And while all this is going on, where does the EU regulation number 261/2004 fit into this landscape?
Well, good question. That's got a lot of attention in the legal industry. Well, the regulation has remained unaltered despite the airline industry's request for its suspension or amendment, given the rather uncompromising requirement in Article 8 to reimburse passengers the full cost of their tickets within 7 days of a cancelled flight. Many airlines have perhaps unsurprisingly struggled to meet their refund obligations, and it remains to be seen whether regulatory or even group litigation action will be taken in response. There's certainly been threats within the UK, I think from Which magazine, and more widely across Europe from other European consumer groups, that such action will be taken. So we'll wait and see. In terms of outside, moving away from Article 8, looking at Article 7, right to be compensated for delays or cancelled flights, well, the global pandemic itself is likely to constitute an extraordinary circumstance and therefore a defence to a claim for compensation under Article 7. But the right to rerouting for a cancelled flight and the right to provide with care, things like hotel accommodation and refreshment, in Article 9, well, that remains. So notwithstanding the substantial problems that carriers might face in dealing with the consequences of the pandemic, when flights have to be cancelled or substantially delayed, those measures are still very much, or those obligations are still very much in place.
Well, Chris, thank you so much for talking us through this ever-changing area. Before we go, where do you think these changes leave the travel industry?
Well, it'll be interesting to see whether testing at airports or other ideas such as biopassports or health declaration forms become more widely adopted as an alternative to self-quarantine measures, which those measures are clearly having a hugely detrimental impact on the travel industry at the moment. Or whether, for example, more localised quarantine restrictions are put in place. Given that many parts of Spain and France, for example, have far lower rates of infection than most of the UK, one thing that is a potential route that government might go down, certainly one that the aviation industry is pushing for. But ultimately, to try and end on a cautiously optimistic note, I think given its ever vigilant focus on safety, I think the aviation industry is one that is well placed to lead the charge in adapting to what is clearly a world profoundly changed by COVID-19.
Thank you, Chris, again for talking us through all that. And thank you for listening to this Hare Court Travel and Aviation Law podcast. For more information on the services that Hare Court can provide in this area of law, please do visit the Hare Court website, and please keep an eye out for further episodes of this podcast series. Thank you for listening.